All right, we're going to cover legal issues from Module 6. I'm not going to cover information on every slide because some of this is self-explanatory. Much of the information on these slides is definitions and just factual information as far as knowing it and remembering it. I will definitely hit highlights that are pertinent to student nursing care, legal implications for nurses, etc. The objectives associated with legal issues include discussing the components of the North Carolina Nurse Practice Act, discussing elements of advanced directives and informed consent and the responsibility of the nurse, verbalizing the legal responsibilities of nursing students, describing the legal responsibilities of nurses regarding HIPAA, and discussing mandatory reporting and the importance of compliance in healthcare. Okay, so law is pretty straightforward, statutory laws. Let's go to the section under statutory laws that affect nursing practice. Nursing laws are state statutory laws. Each state has a Nurse Practice Act. We've discussed this before, that determines the scope of practice for a nurse in that state. And then the statutory laws that affect nursing practice are statute of limitations, okay, protection and reporting laws, natural death acts, and also informed consent laws. State boards of nursing are administrative agencies given power by legislature to interpret and enforce law. These slides are just, again, definitions. Some of these would apply to nursing. For example, if a nurse were to commit a crime while practicing as a nurse, criminal law applies. The definition of a crime applies to a nurse while she's practicing. Just because she's a nurse and dealing with patients doesn't negate the fact that it is a crime. And then also civil law deals with the rights and duties of private persons. A tort is a civil wrong committed against an individual or individual's property. And so this we'll discuss later in malpractice. Tort law, this slide is self-explanatory. I'm going to cover some specific content on this slide. This is under the heading of unintentional torts. So negligence is a type of unintentional tort, and negligence is defined as a conduct that deviates from what a reasonable person would do in a particular circumstance. And a reasonable person is further defined as a comparative standard that describes an individual in society who exercises average care, skill, and judgment. So we're going to now apply this to nursing and say that a reasonable person in the nursing world would be a reasonable person, a nurse, who compared with other nurses would exercise the average care of a nurse, the average skill of a nurse, and the average judgment of a nurse. So reasonable person here doesn't compare a reasonable person who works as a, I don't know, it could be anything, works as a garbage man, compared with a nurse in respect to average care, skill, and judgment. So that means that if I do something negligent as a nurse, I'm not compared to other people who don't have my skill and training. Okay, I'm compared to other nurses who have that skill and training. Does that make sense? So we're comparing apples to apples when you talk about what a quote-unquote reasonable person would do. A negligent act occurs when an individual damages person or property without intent to injure, which things do happen without intent. Unfortunately, things do happen that injure another person, but we didn't intend for that to happen, right? It could be due to carelessness, all right, unfortunately. In a legal action to establish negligence, the injured party must prove that the other party had a duty of reasonable care, okay? That I, as a nurse, so the patient could say that I had a duty of reasonable care to protect that individual, to prevent them from falling out of bed, to whatever the unintentional negligence was. That the other party did not maintain reasonable care, that I did not do what I should do as a nurse, okay, with the average care, skill, and judgment of a nurse. I didn't perform those duties in that way. and that the failure to maintain reasonable care cause injuries to the aggrieved party. Okay, and I'm just explaining this to you so that you understand that it's set up. There's a system set up to understand that we're talking about nurses trained in this way to provide care to these individuals did or didn't do what they should have done in comparison with another nurse in that same situation. Okay, so let's talk about malpractice. This is also under the heading of an unintentional torts. A reasonable person, the reasonable person standard is different for specific professional occupations under malpractice. So malpractice doesn't apply to the person working at the bank or the person working at the electric company. Okay. Malpractice includes acts and omissions committed by a professional in the course of performing his or her professional duties. Okay. Standard is a conduct of reasonably skilled, competent, experienced person who is a qualified member of the group authorized to engage in the activity. All right, so that means that as a nurse, I'm reasonably skilled and competent, I'm experienced, and I'm qualified to participate in the group of nurses engaging in nursing care. Failure to meet the standard of conduct for one's profession may be considered professional negligence or malpractice. Okay, so there could be negligence associated with injury or harm to a patient, and then it could even go further to it's a standard of conduct. One of the most important areas of law for nurses is malpractice. It's any negligent act or omission, however unintentional, may jeopardize a nurse's license, and also because of jeopardizing patient safety, jeopardizes the nurse's license. Anyone, qualified or not, who performs skills associated with a profession is held to standards of conduct of those who are qualified. Okay, so that means that if I'm performing a skill in the performance of my duty as a nurse, I'm held to that standard. So that I don't get to say, well, I mean, there are other nurses who are qualified to do that, but I'm not qualified. If I've been trained and deemed competent in that skill, then I'm a group of people who are qualified to do that. Okay, and the reason for that is that we can't sort ourselves out like, well, I'm not okay to do that. There is a level of training, yes, but the public relies on special expertise of the profession, okay, nurses, doctors, things of that nature, and nursing students are held to the same standard of conduct as a licensed nurse. That means that you need to adhere to the policies of the clinical setting where you're performing, that you basically follow the rules and regulations. You can't just say, oh, wait, no, I'm a student. No, you're performing as a nurse qualified in this area to do XYZ number of things. So it's really important that that's why we need to stay in our lane, that we don't get out of our lane and doing things that we're not trained to do, that we're not qualified to do. And so that means that a reasonable person under malpractice would say that, hey, I'm not trained to do that on my own. I need assistance, or I need further training. That's also a responsibility that you have, not only to do what you are trained to do, but to stop and bring it to someone's attention when you're not properly trained to do something, a procedure or a skill or a task that you're not trained to do. That could potentially result in patient harm, and we don't want that. So malpractice isn't, nurses can be charged with malpractice. It's not only physicians, but it's, in numbers wise, I can't really say the statistics on it. It's really it's kind of a moral and an ethical thing. If I'm charged with doing these number of things in 12 hours, then I'm going to do them in a way that I was trained to do, that's safe and demonstrates competence, and also document the fact that what I have done in the manner that I've done it, and to also step forward and say that I'm not trained to do that. It's not acceptable. It's not safe. It's not, whatever the situation is that doesn't put you in a situation to be held, to negligence or malpractice, when you should have just stepped forward in the beginning and said that you shouldn't be doing it. All right, a little bit more about malpractice. The elements of professional negligence or malpractice is that it's a duty. Okay, you were called to that duty, that you're performing a breach of duty, either by commission or omission. And those are the two things I talked about, that you're going forward and doing something that you shouldn't be doing, or on the other hand, that you're not doing something that you should be doing. Foreseeability. It is your responsibility as a nurse to foresee the potential consequences of your action or inaction. And foreseeability makes it malpractice because you didn't act on that, what you foresaw to be a consequence. Causation. Your action or inaction caused whatever. And then injury or harm is also an element of malpractice. The purpose of a malpractice lawsuit, is to award damages to restore the plaintiff, so the person complaining, to an original position as far as possible. Damages are defined as compensation, so monetary compensation for a plaintiff's loss or injury. And then there may also be punitive damages to the individual causing the damages if misconduct is deemed malicious, willful, or wanton. We don't get into this specifically. It's just information. This would be a nuts to know, to be quite honest. There are related doctrines that address malpractice. Statute of limitations addresses the amount of time that can pass between the recognition of harm and the bringing of a suit. So if the statute of limitations is 1 year, that means only 1 year can pass between the time that the harm occurred and the initiation of a suit against the defendant. It varies by the type of suit, and this is a law thing. This isn't a nursing or a medical thing. This has to do with the law. It varies from state to state. Application to minors varies from state to state as far as if the harm was caused to a minor child. And then also some states have extended time limits for certain types of injuries. We don't get into that specifically. You just need to know that this stuff is out there. You can't be blind to it because it can affect your livelihood even. Okay, let's talk about intentional torts briefly. Intentional torts there was an intention. There were actions taken by an individual with intent to perform the action. So it's different than not preventing a fall, but actually I would hate to think that someone would do this, but none of you certainly will, push a patient to fall. This is separated from negligence and malpractice by a willful nature. There was an intent behind the action. Examples of intentional torts are assault, battery, and false imprisonment. It goes on to explain those. Assault is the act of creating an apprehension of offensive, insulting, or physically injurious touching. So assault is actually the touching and also the threatening for touching, offensive, insulting, or physically injurious touching. Battery is a willful touching or apprehension of touching that is unwanted, embarrassing, or unwarranted. And this includes touching without permission, giving an injection without a patient's consent, forcing a patient to ambulate against his or her will. False imprisonment is unjustified detention of a person without a legal warrant. And this includes confining a patient to a bed with intent to restrict a patient's freedom. The standards of care prohibit a nurse from forcing patients to participate in treatment and from engaging in any action against a patient's will. Patients have the right to refuse any and all treatment. In very limited instances, are they not allowed to leave a facility against medical advice. But again, if you're in a situation and you're not sure what to do about it, you need to ask. This would be a need to ask somebody else type of situation. First start with the resource nurse, if you're an employed licensed nurse, and then go from there. elevate it, and they will elevate it to the appropriate individual. Another intentional tort, which is probably far more common than any of those we've talked about so far, the invasion of privacy. Individuals, including patients and clients, have the right to privacy. Information about patients is confidential and may not be disclosed without authorization. So HIPAA comes into play here. The patient's right to privacy extends to the use of the patient's name, photographic or videographic representations of the patient. So taking a picture of the patient's, this can be a little bit sticky. Some hospitals use a consent that the patient agrees to allow, for example, their wounds to be photographed. Other hospitals use the general consent that the patient signs on admission as the consent that covers that. So that's going to be facility specific. Patients, their faces, unless it's for the reason of photographing a wound, should never be photographed. Patients should never be photographed for entertainment or recreational purposes, either on the part of the staff or on the patient. It can get a little bit sticky. I've had patients ask to take a picture of me, with them because they're getting better and they're leaving the hospital and they're appreciative. And while those things, I believe, most often are well-meaning, sometimes in the wrong hands, those things can be misconstrued. And so I decline. I'm more than happy to take pictures of, the family and the patient at the car, or, I really try to limit it, to be quite honest. No photography in any way. I just really try to say, hey, I'd rather not, but I'm happy to plug your phone in for you and make sure that it's ready for you when you get home, or something of that nature. But if you have any questions about the propriety of what you're about to do or what you've been asked to do, please ask somebody. Please, please, please. The right to privacy includes a patient's personal belongings and their personal space. Most healthcare agencies have policies and procedures that specify to whom and under what circumstances patient information can be released, and policies and procedures specifying how we manage patient environments and their personal property. Again, this is going to be facility specific. The right to privacy is universal across healthcare, but how it's managed in a facility is going to be policies and procedures that belong to that facility. Failure to follow policies can lead to a claim of invasion of privacy. And nurses are bound by the privacy rule of HIPAA. We've talked about this. HIPAA protections are minimum requirements, okay? We need to, we release the minimum amount of information that person requires. And also, minimum requirements also means that HIPAA is like the very minimum protection. Of course, it could be more than that, as far as all the way up to no information released about a patient, but minimum protection of their name, their social security number, their diagnosis, their room number, all of that type of stuff can be protected. And again, like a room number, for example, could be, hospitals may have their own specific policies about releasing patient room numbers. Again, state law and professional codes may include more strict protections, but HIPAA are the minimum requirements protected. If you have questions about HIPAA and what you're releasing and to whom, please go to somebody who can provide you with the right answers, or go to the facility's policies. Let's talk about some ways that we can prevent incidents of professional negligence. We need to be forthcoming with any medication errors that we have committed. It must be clearly documented, and if you're unclear about how to document an error, you need to get with your resource nurse, and then also that individual can help you, guide you about how this can be discussed with the patient. Sometimes it needs to be done by the physician. It depends what the error was. So just be forthcoming. Hiding something and trying to brush it off can be disastrous for yourself, your career, your patients. It's just be forthcoming. And the first person that you should go to would be either your clinical instructor, if you're a student in the clinical setting, or the resource nurse, whoever's your immediate supervisor, if you're an employed licensed RN. Other problematic situations that can lead to professional negligence are communicating care concerns and key information about the patient's condition, and this goes along with HIPAA. We also need to ensure that the physician's orders are clear, so we'll talk about that a little bit more, but if you have any question, if there's any piece of a physician's order that is not clear to you, it needs to be clarified before you carry out any part of that order in the care of a patient. You need to understand how to use equipment. This can lead to injury to both yourself and to others, primarily, most importantly, patients, but also even other staff. Make sure that you're appropriately trained and you understand how to use the equipment. Again, this would come right up there with, if I don't know how to use it, I need to be trained and be educated on how to use it appropriately before using it on a patient. And then we need to provide appropriate mentoring, assessment, and care plans for patients. So we need to be mentored appropriately in our work situation. We also need to be completing the appropriate assessments, and we also need to be establishing, developing the appropriate care plans, and also carrying out those care plans for our patients. Okay, so let's talk about maintaining patient safety. Safety is probably one of the areas that gets the most attention when it comes to like negligence and lawsuits and malpractice and things like that. So let's talk about failure to observe and take the appropriate action in relation to falls. Okay, a nurse is liable for malpractice if a patient is injured as a direct result of nurse action or inaction leading to a fall. Okay, so action would be, of course, if I pushed a patient, that's action. I caused that patient to fall. And then the other thing would be inaction leading to a fall. So I know that this patient is at a risk for falls for whatever the reason. It could be medication related, it could be disease process related, it could be cognition related. There are a whole host of reasons, but I did not take the appropriate actions that would prevent, or as much as possible prevent, that patient from falling. Okay, so those are problematic, action or inaction. Most hospitals and nursing homes have policies regarding the use of safety devices. So those would be use of restraints, use of bed alarms, use of chair alarms, things like that. These are devices that are available, not restraints, but bed alarms and chair alarms that can help us alert that a patient could be, heading towards a fall. They've tried to climb out of bed or they tried to get up out of the chair. So if you have a question about what's available in your facility and how it should be used, you need to contact either your preceptor if you're on orientation, or your resource nurse if you're employed there and you haven't been educated on those devices. Another incidence of failure to observe and take appropriate action is the ignoring of patient complaints. Okay, it is a type of malpractice, and the patient complaint could be about anything. Now that doesn't mean that harm came to them, right? But if it's a complaint that did result in harm to the patient, that's can be considered a malpractice situation. Incorrect identification of a patient. I can't even, this is so foundational to safety. So, and this is everywhere from, this is not just nurses, it's everyone who cares for a patient is required to confirm that they're providing the correct care for the correct patient. So in the situation of a nurse, incorrect identification of a patient can lead to the patient receiving the wrong medication or the wrong dose of a medication, or receiving the wrong treatment, maybe the wrong dressing change. So it is so important. This also can lead to occurrences such as surgery on the wrong patient. So that's out of the inpatient setting as far as on the unit, but there are nurses in the operating room who are partly responsible for correct identification of a patient. So it is so important not to skip steps and try to, find a way around the system. Don't do that. Just don't. These situations can render a nurse liable for malpractice. Okay, so we've talked about this briefly. You've started your medication administration modules in ATI, so nurses need to strictly apply the 7 rights of medication administration. Now, there's one piece in here that we do not include. It's not a wrong answer, but it's not our teaching of the rights of medication administration. So the right assessment is not something that we include. It is not wrong. The right assessment of your patient needs to be included in giving the patient medication. So the right assessment would include things like taking the patient's blood pressure before you administer a medication for their blood pressure, right? So it only makes sense that that is a correct step. We do not include it in our 6 rights of medication administration. Just know that assessment is an expected standard of care when administering medications. So the right drug, the right dose, the right patient, the right route, the right time, and the right documentation. New technology such as electronic health records must be evaluated for effectiveness in reducing errors. So some things have, technology has helped us prevent errors in such ways as scanning the patient's name bracelet on their wrist and in association with scanning the medication. So there are some things that have helped us reduce errors in medication administration. Nothing can replace nursing judgment in preventing medication administration errors. Let me repeat. Nothing can replace nursing judgment in preventing medication administration errors. So that includes clarifying unclear orders. I mentioned that earlier. If any part of the physician's order or the physician assistant order or the nurse practitioner order is unclear to you, stop. Stop and clarify the order before proceeding. That will stop the patient from getting the wrong drug, the wrong dose, the wrong route, the right time, or the wrong time, I'm sorry. So stop, okay? Get any of your questions answered. If you're, again, that goes back, if you're unclear about any piece of a physician order, stop. That right there can avoid so many issues. Once you give a medication, you can't get it back. So stop and make sure you have all of your pieces where they belong before you proceed to giving a medication to a patient. And then know each medication before administration. There are many medications, unfortunately, who have a similar name and can be confused. Maybe just 2 letters are different that completely, I mean, those 2 drugs are maybe not in any way similar. And one would cause harm to the patient while the other one would be part of their treatment plan. So it's important that you know each medication before you administer it to the patient, what it does, why that patient is getting that medication. It's important. If you have a clinical instructor who insists that you have this information before you give it to a patient, good for them. Good for them. They should. They must. It is also incumbent upon them to practice safely and safe medication administration for your patients, for their patients. Okay, so we've talked about this a lot and we're going to continue to talk about it. Effective communication. Poor communication coupled with a negative outcome increases the chance of a malpractice claim. So if along the way there were instances of poor communication that then at the end had a poor outcome for a patient, there's a likelihood that someone will find it, i.e. a lawyer, and increase the chance of a malpractice claim. Clear communication of directions and explanations, provision of effective patient education can help decrease the risk of bad outcomes. So again, we need to assess, what does your patient know? How well do they understand what you have just told them? Provision of effective patient education, providing written directions, things like that can help decrease the risk of something untoward happening. Attentive listening skills can demonstrate caring. Not only is this super important, but if an individual, even if they've had a bad outcome, believes that they were cared for appropriately, that they were being heard, that their best interests were at the forefront, they're less likely to file a malpractice claim. So that's not the reason to use attentive listening skills. It is, though, part of the psychological aspect of a bad outcome. Accurate documentation and reporting provide information to support or refute allegations of malpractice. Please, please, please keep in mind that your nursing documentation serves as a legal representation of the care that you provided. A medical record is a legal document. So that's why we say if it wasn't documented, it wasn't done. I mean, that sounds like I've heard it forever. We've heard it forever, but it is true. If whatever you're doing for that patient, to that patient, with that patient needs to be documented. Nurses should document defensively and be inclusive, not rely on their own or patients' memories of the details of care. So that means that you should include everything that you have done, like I said, for that patient or with that patient. If you believe that tomorrow or in a month or in a year or in 3 years, when a malpractice suit comes, that you can remember what happened on September 25th, 2020, you're wrong. It just doesn't happen. Some really compelling studies have been completed on the ability to recall events after the passage of time. So many things happen between today, when this event occurred with the patient, and they're bringing a suit. I mean, just like regular old everyday life stuff, that remembering the details that could protect you in the event of a malpractice suit are super unlikely. So document, document, document. That is your legal representation and protection against someone else's word of what happened in that episode of care. Okay, let's talk about professional liability insurance. The very first sentence on this slide says that nurses should carry professional liability insurance. This came from Pearson. It is not something it is not my opinion. It's not something I'm going to insert here, my opinion. It is available to nurses, and that's really what I'm going to say. That's really a personal decision. If a facility that where you're employed requires that you do, that's between you and your employer. So all I'm going to say is that it's available. Most often, facilities don't pay for nurses to have malpractice insurance. It would be something that you pay for out of pocket. And then the last bullet on there, the two last bullets on this page indicate that nursing students generally are required to carry liability insurance for the duration of the education program, and that some programs insure students under a broad institutional policy, which is what happens here. It's included in your part of the program process. So just know that when you become a licensed professional, that malpractice insurance is available to you as a nurse. Okay, let's talk about the standard of care. The standard of care is based on the applicable Nurse Practice Act in the state where you practice, the applicable administrative rules of the Nurse Practice Act, as well as the facility where you're employed, and also job descriptions. Okay, the laws are not static, so an employed licensed RN needs to be aware of any changes to the law. Ignorance of the law doesn't, or I shouldn't say the law. Ignorance of the standard of care doesn't negate its presence. Employers can limit but not expand the scope of the practice. So if the Nurse Practice Act in a state says that you can do things A through D, the employer can say, we acknowledge that, but in this facility, nurses can do things A through C. They cannot say nurses in this facility can do things A to G. So they can limit what you're able to do in the nurse's scope in that facility, but they can't expand it. And the nurse is held to the functioning within the scope of their employment. So you can't override that and say, well, I know what you say, but the Nurse Practice Act in this state says that I can do A to D, so I'm going to do A to D instead of A to C, like my job says. That's not a valid assertion. Agency policies and procedures define the standards of care. If there's a conflict between the current practice and the policy, the nurse should resolve the conflict through quality improvement programs. So if there's a conflict between current practice and the policy, those things should be addressed, because our policy should always drive our practice, not the other way around. I don't decide I'm going to do something and then develop a policy that fits that practice, right? I develop a policy that's based on evidence, patient safety, a bunch of different elements, and then develop a policy that supports those things, not the other way around. So keep that in mind. And the way to change practice is to, and policy. So go to the evidence, and that's why we talk about PICO strongly here in NUR 111, because that's how we decide, well, wait, what we did 5 years ago isn't really up to speed, and we've seen through study and research that now this practice leads to more efficient and safe healthcare. So that's why evidence is important. So evidence will then drive the practice as far as like, oh, now we can see this should be the standard of care, right? And so we're going to now talk about what policies fit both the practice and the facility's abilities and capabilities and things like that. Prevailing national nursing standards define the standards of care. So the American Nurses Association standards of practice is the overarching agency that kind of helps guide the different boards of nursing in the different states. And then there are also specialty practice standards. So there will be pediatric specialty standards and things like that. What apply to pediatrics doesn't apply to adults and vice versa. So there are specialty standards as well. Selected laws that affect nursing practice. Individual states have the freedom to enact additional legislation. They may further define or restrict aspects addressed by the federal law. And then all nurses should be aware of laws that govern and or affect nursing in the state where they practice. So let's talk a little bit about the elements of the Nurse Practice Act. The Nurse Practice Act in the state of North Carolina addresses such things as the qualifications for applicants applying to test for the registered nurse licensure, ways that licensure can be obtained, which can be by exam in the case of individuals just graduating from nursing school, or individuals coming from perhaps another country, or where they require a testing because they haven't graduated from an accredited nursing program in the U.S. And then there's also licensure without exam, but this only applies to those individuals who have held a registered nursing license in good standing in another state. So in that case, you would fill an application, pay your money, they would do a background check, and then go forward from there. Rules regarding re-examination if an applicant were not successful during exam, the renewal of registered nurse licenses, the reinstatement of a license if it has been in inactive or restricted status, disciplinary action, and also standards for nursing programs in the state of North Carolina. So in this slide, I've included ways that the both Registered Nurse Scope of Practice and the Registered Nurse Practice Act in the state of North Carolina can be accessed. Patients have the right to give informed consent voluntarily. Patients must not be coerced. That's never acceptable. Patient understanding is essential. So again, we're going to go back to avoiding technical words and understanding that language barriers can inhibit understanding. If the patient cannot read, the healthcare provider must read the consent form to the patient. And then the patient must state understanding before they sign the form. So the best way to do that is to have them repeat back what they heard, okay? And then provide clarification from there if necessary. And if a patient and a healthcare provider do not speak the same language, a medical interpreter must be present. The nurse should follow the employing agency's specific protocols. So there's a couple different areas. There are a couple different schools of thought on this. And when I say on this, let's go just a couple of things that are not negotiable. A nurse, unless they are the person who will be providing the treatment or the procedure, which I said that's rarely the bedside nurse. The nurse is not responsible for explaining the procedure and answering questions for the patient. That is the physician, the physician's assistant, or the nurse practitioner's responsibility. So if they say, hey, go ahead, the provider says to you, go ahead and have the patient sign the consent. I'll be up to talk to them later. No, sir. Nope. It'll be here waiting for you when you arrive, and I'd be happy to provide you with the consent, a clipboard, and a pen when you get here. That's not your responsibility, nor are you to do that. That is absolutely not okay. The other thing that there's a couple ways that this can go down, so let's just talk about them. Sometimes the physician will come out of the patient's room and they'll say, I just talked to the patient, answered all their questions, go ahead and have them sign the consent. That would be a place where it would be a little bit gray as far as the facility's protocols. So know the policy of the facility where you're working. I would say this is a place where you need to be very clear about the policies in the facility where you work, because if a patient consents to something, I mean, if you had a patient sign a consent for something that they really legitimately did not understand because the physician hadn't either explained it appropriately enough or answered all their questions or whatever the situation is, and you're having the patient sign the consent, that's just gonna that's a setup for such bad outcomes. So again, if you have questions, just don't do it. Just stop and have it clarified before you go ahead and do something that's kind of irreversible. Once the patient signed the consent, I mean, the physician could really run with that. I mean, the patient signed the consent. So just be very, very careful. Like I said, if you have some questions, have them cleared up. A consent must be obtained for all procedures and treatments, including nursing care. So that does not mean that every time you go in a patient's room, you have a consent signed. A patient signs what's called a general consent when they're admitted to the hospital that covers general types of treatments to include, baths, ambulation, dressing changes. I mean, you see what I'm saying? Like general overall nursing care. However, during the course of their admission, they may experience things that require a specific consent. So they came for one condition, but then during their stay realized they need to have their gallbladder out. Well, that requires a separate consent because that wouldn't be covered under the kind of general, that wouldn't be a normal occurrence, right? Surgery during your hospital stay. If they came for a specific procedure, that procedure has to include its own consent. Procedures like insertion of a PICC line, and that's a place where the nurse probably would do the consent, but it would be the nurse inserting the PICC line, not the bedside nurse. But typically nurses do insert them, so that's why I'm saying it could be a nurse, but typically not the nurse at that facility. So just be mindful if a patient's going for anything that seems kind of like out of the norm to a specialty area, cardiac catheterization, oh my gosh, anything in the operating room, things like that require their own special consents. When in doubt, ask. An expressed consent is an oral or written agreement. Okay, so I've expressed my consent to have this treatment completed. And then implied consent is a nonverbal expression of a consent indicated by the patient's actions. So implied consent is that I come in, I'm unconscious, I have a breathing tube in, I have IVs going, I've been in a car accident that's traumatically amputated one of my legs. The implied consent is that I want treatment for this. I'm nonverbal because I'm not able to express that, but that would be the reasonable standard of care for that condition. Now, once I wake up and I've decided, if I want treatment stopped or I want to pursue another treatment. Okay, now we're in a different place, but implied consent means that the standard of care will be applied to that individual if they're not able to express consent on their own. Talk about competency, and this can be a little bit tricky. An adult is assumed to be competent if they are over the age of 18. They are not declared legally incompetent, or they have not been rendered temporarily incompetent. Okay, so the assumption is that if you come to me and you are alert and oriented to time, person, place, and situation, you're over the age of 18, we're having a conversation and you can express to me, you know, what the treatment plan is and that you've consented to it, then in the absence of additional documentation otherwise, then I consider that individual competent. Adults who are declared legally incompetent are provided a legal guardian who would then step up and make decisions for them. A person may be rendered temporarily incompetent by medication or by a serious fall. So that would typically, you would be cued into that by the fact that they're probably not alert and oriented times 4, or there seems something is amiss. They're not responding appropriately. They're not conversational. They can't, you know, follow simple instructions. An individual may become incompetent gradually through dementia. If a provider determines that a patient is not competent for the purposes of informed consent, it's possible that an emergency consent may apply. That's up to the physician. And then another individual to make healthcare decisions for that individual, we may need to pursue that. And again, that's typically the physician pursues that. The courts may presume continuing competency unless the healthcare facility can show that a patient cannot understand the consequences of his or her actions. So I have seen some situations where the patient just doesn't seem competent, but it takes a series of steps. It's not just the nurse is like, oh, I don't think this person's okay to sign this consent. That's not just going to be enough. So it's usually a series of steps to decide if this person can continue with consent. Sometimes psychiatry has to get involved. It depends on what the situation is, but it's not as simple as like, yeah, no, they don't seem competent. I mean, it's quite a process, and I've even been through a couple of them where it seemed pretty clear that the individual was not competent to sign consents and things like that, but no one would come out and say, including psychiatry, that they were not competent. In that case, your hands are a little bit tied. If there's no one who will deem them incompetent. Okay, we talked a little bit about this at least one time in class, consent in an emergency. The law usually assumes that the person will consent to a medical treatment in situations when the person is in imminent danger of loss of life or limb and are unable to give informed consent. Again, so that would be my example. I came in, traumatic amputation of my leg, and I have, you know, I'm on a ventilator. So likely, I would consent to treatment, and treatment would continue until the individual, either someone steps forward as their healthcare surrogate, or I become, you know, appropriate to say that I don't want to continue treatment. It assumes that the person would reasonably consent to treatment if they were able to do so. An emergency consent permits healthcare providers to perform potentially life-saving procedures when obtaining a consent is impossible or impractical. It does not always apply, however, it does not allow providers to perform treatment to which a patient would not reasonably consent, and it does not allow providers to perform treatment to a patient that has previously refused that same treatment. So an example, this happened to me with a patient, so this would be an example of that. Aside from the accident, I took care of a young woman who had a cardiac arrest in the recovery room after she had a C-section. She was very young, first baby. So she came to the ICU and she was on a ventilator, and they were trying to decide, you know, what caused this. She was otherwise young and healthy, and so what are we going to do for her? So in the course, though, of deciding what had happened and what they were going to do from here, she had a postpartum hemorrhage. They were unable to stop the bleeding, and it was decided that they would do so what happened was they she did have a mother, but she was an adult. She was not married, so her mother was her next of kin. However, we couldn't reach the mother for whatever the reason. She'd, like I said, just given birth, and I think they were trying to get some legal things in place. Couldn't get in touch with the mother, and her condition deteriorated to the point where she requires an emergency hysterectomy to save her life because she was bleeding. And so they did that. So now we had a 21-year-old who had one baby, was unmarried, but was not able to any longer have children. So, but that was an emergency. So the flip side of that would have been to continue to try to stop the bleeding. They had not been successful to that point, and so she was going to likely bleed to death if they hadn't done something. So that would be an emergency where we were not able to contact the next of kin, and the patient obviously was unable to provide consent for herself, but that was a life-saving procedure. So that would be an example. And they're pretty extreme. It's not something like hey, you have this hangnail, do you want me to amputate your thumb kind of thing? No, it's not that. They are life-saving measures. All right, child participation in healthcare decisions. A parent or guardian must give informed consent for a minor child who is under the age of 18. The exceptions to this would be when the emergency doctrine applies, so it's an emergency. And usually that they're unable to get in touch with the adult responsible. When the child is an emancipated minor, when a child is a resident in a state that allows a mature minor to give consent, when there's a court order to proceed with treatment, when the law recognizes that the minor is as having the ability to consent to a specific treatment. So those are very individualized cases, not things that those are not everyday type things. And typically the physician, case management, social worker, the resource nurse, they would be involved in those types of things and try to get that stuff ironed out. Usually it does not, I would say rarely fall to the bedside nurse. In most states, a minor who has a child may give informed consent for the child's treatment. Some states permit teenagers of a certain age seeking certain types of care to do so without parental consent. And examples of this would be contraceptive services, prenatal care, and mental health counseling. So just be mindful. There are situations that are, again, as we spoke of the other day, many situations, not black and white. Most often in these types of situations, the bedside nurse needs to go to a resource and try to decide how we're going to iron this out, because we, as nurses, typically don't have the expertise required to sort out the legal implications and who can do this and then who can do that and then where's the paperwork, and so those types of things. So please ask and get a resource to help you out with that. Okay, let's talk about controlled substances. Federal law requires that drugs are classified on the basis of the drug's medical use, the potential for abuse, and the safety risks. Drug classifications are referred to as schedules. The schedules are numbered from 1 to 5. Schedules 1 and 2 have the highest potential for abuse. The Controlled Substances Act is enforced by the U.S. Drug Enforcement Agency. Registration is applied to each drug that has unique identifiers for legitimate handlers of controlled substances, and requires record keeping that traces the flow of any drug. Each state has its own requirement for prescribers. Good Samaritan laws, these apply to nurses outside of the hospital. So this is not in the day-to-day performance of your job. Good Samaritan laws encourage healthcare providers to help victims in an emergency. So this would be something where maybe you came upon a car accident, or saw someone came out of a burning building and you rendered aid, or something of that nature. They're designed to protect healthcare workers from potential liability when volunteering their skills outside of the employment contract. So I said this is not in the hospital. This is outside, but you have the skills to render aid. But then there's the kind of thing like, again, ooh, I helped somebody, but it didn't turn out well, so what's going to happen now? But these laws are put in place to protect those individuals. To be protected by the law, a nurse must adhere to the standard of nursing care. So they can provide only care consistent with a nurse's level of training and licensure. So that doesn't mean that I can, I come across a motor vehicle accident but I can now do surgery on the side of the road. No, that's not what I was trained to do. I would do things like CPR. I would go through ABCs. Those would be within my scope of practice, things that I were trained to do. And after having decided to render emergency care, the nurse must follow through in providing the necessary care. So you can't get into it and then decide that, nope, I'm in above my head, too late now, okay? And they follow through until they safely place the victim in the care of someone who can provide the appropriate care. So I provide care, I continue doing what I'm doing, for example, CPR. I'm going to continue doing CPR until I physically can't, and that is a legitimate reason to stop. I physically cannot, or until EMS arrives and they can take over the appropriate care of the person. Okay, whistleblowing laws. Whistleblowing is a disclosure of an employer's unsafe or illegal practices and or policies by an employee. This goes through some of the things of the whistleblower, the protections that it provides. Most facilities, healthcare facilities, provide an anonymous reporting, which whistleblower is, they are anonymous, but again, there are sometimes other channels just through the facility themselves. So be mindful that these laws exist. We've heard about them, of course, in the news, but they are put in place to allow unsafe or illegal practices to be brought to light. Okay, lifespan considerations. So let's talk about some legal implications when talking about different areas across the lifespan. Infants and children. Nurses are mandated reporters of observed or suspected child abuse. Nurses who fail to report abuse may face civil charges. Reporting laws vary by state. Reports should be complete, accurate, and made according to the organization's policy. Again, if you're not familiar with or you're unclear about how to make the appropriate report, again, go to your next resource. The nurse should also personally report the abuser to the report the abuse to the proper authorities. You can ask within your facility how these will be reported to the authorities. Again, this came from Pearson. I would go through facility channels and be sure that you have done your due diligence as a nursing professional, and then ask what further requirements are for you to report. All pertinent information is required by law to be disclosed to the reporting agency. The nurse is required to report facts or circumstances that led to the belief about the abuse. That does not have to be a burden of proof. Again, we talked about this the other day. You provide the information about what you assessed, what you saw, the facts, okay? Reports must be made in good faith without malicious intent, and most states allow anonymous reports but may encourage the reporter to provide identifying and contact information. As far as adolescents are concerned, nurses should be familiar with the federal, state, and local laws related to adolescent confidentiality. Nurses should ensure that patients understand that confidentiality will be maintained when possible but cannot be guaranteed in some circumstances. And again, before you announce that to a patient, make sure that you know what you're talking about, because it shouldn't turn into a battle unnecessarily. Okay. If the patient is covered under the parent or guardian's insurance, billing and benefit statements may include information about the care, right? Authorities must be contacted if the patient is in imminent danger, if there is evidence of abuse, or if the patient has certain communicable diseases, regardless of their age, right? And then there's the use of electronic health records. A parent or guardian may be a proxy into the electronic health record, so they may be able to view the information about the visit or the encounter. And then some of these EHRs can be customized to restrict information. But again, that's from system to system according to the software, and that doesn't have anything to do with the nurse. Just keep in mind, though, that again, just because they're adolescents doesn't mean that they're not intelligent and want to participate in their care. So when providing confidential care, the nurse should encourage the patient to consider involving the parent and guardian in decision making, right? Because they're parents, and we understand that you're trying to become an adult, but there may be some things that are worth sharing with your parents. And make clear that this is a suggestion, but it's not a requirement. Okay, let's talk about pregnant women. This can be sticky, and there's a lot of different aspects involved in the care of pregnant women. So In 1973, the Supreme Court's ruling of Roe v. Wade found it unconstitutional for states to outlaw abortion during the first trimester of pregnancy, but placed restrictions on the state's ability to regulate abortion during the second and third trimesters. There are, so just know what's going on at your facility. There are facilities, healthcare facilities who provide abortions, others who do not. So just kind of know if you're dealing potentially with a sensitive area such as this, that you don't speak out of turn with relation to what's legal and what's not, etc. State statutes still control abortion and vary from state to state. They include regulations that are related to gestational limits, insurance coverage for procedures, and mandated counseling. Some states have passed fetal protection laws, and there may be questions about the woman's right to refuse certain tests or treatments. Again, this is pretty specific and should be handled delicately, with knowledge, though, as not to offend anybody or speak out of turn about legal precedents or consequences. The nurse themselves may face moral or ethical dilemmas, so you need to know the laws in the state where you're practicing, and as well as the organization's policies. And you should understand your rights as an employee, and also the procedures for conscientious objection. Again, that's something that would be worth probably investigating prior to accepting employment with a facility that provides potentially objectionable treatments. Older adults. In many states, nurses are mandatory reporters of elder mistreatment. Medicare requires that nursing facilities monitor patients for signs of mistreatment. The nurse is responsible for understanding state reporting laws, reporting observed or suspected mistreatment to the appropriate authorities, and failure to report may result in civil or criminal penalties. To help identify elder mistreatment, the State Boards of Nursing and National Center on Elder Abuse offer information. Oftentimes it's required as part of the continuing education requirements for continued licensure, to just be aware of what those signs and symptoms are and what you need to do about reporting. For end-of-life care, whether the person is older or whether they're not. If a patient has an advance directive, the nurse is bound to provide care in accordance with the patient's wishes and organizational policy. If there is no advance directive, patients who are capable of making decisions may work with the nurse to determine the type of care that they prefer. So again, if you're in need of assistance in this area as far as guidance and what you can do and what you can't do, please go to the organizational policy and then also to your next available resource. Okay, that was a lot. There's a lot in legal. It's not, fortunately, things that you encounter every day, but there's always the potential. So kind of start to understand that type of stuff, and especially when you go to work, be aware of the policies in the facility where you practice. All right, let's talk about some quiz questions. A nurse working on a medical surgical unit wants to ensure care is provided within the standard of nursing care. Which actions by the nurse are appropriate? This is select all but apply. Analyze the position description. Review and become familiar with the policy and procedural manual. Question the value of collaborating with other disciplines. Review applicable State Nurse Practice Act and administrative rules, and adhere to national standards of practice and care. And the answers are A, B, D, and E. Nurses are expected to demonstrate competence within multiple areas of their professional role, including collaboration with the entire care team. The nurse's specific job description will contribute to defining the standard of care. Employers can limit but not expand the scope of practice, and the nurse will be held to functioning within the scope of employment. Agency policies and procedures to serve in defining the standard of care. The applicable State Nurse Practice Act and administrative rules form the basis of the standard of care to which each nurse is held. A primary source for defining the standard of care is the prevailing national nursing standards. Nurses who follow national standards of practice and standards of care will provide their clients with the best care possible and be far less likely to commit any unintentional act that may rise to the level of malpractice. The nurse is concerned about being sued for negligence when providing care. Which nursing actions may be grounds for negligence? Select all that apply. A client fell getting out of bed because the call light was not used. The client name band was checked prior to providing all medications. Client's morning medications were administered in the early afternoon. The client states not understanding activity restrictions and the wound eviscerated, and the client documentation did not include the appearance of an infiltrated IV site. Answers to this question are A, C, D, and E. Checking the client name band before providing medications is not an action that is negligent. However, providing medications beyond the prescribed time can be viewed as negligent care. One strategy to prevent instances of professional negligence is to ensure client safety. The client fell when getting out of bed because the call light was not used. Because there is no way of knowing if the client knew how to use the call light, the nurse should be concerned with this situation. Clear communication of directions, explanations, and providing effective client education regarding the client's healthcare requirements can help decrease the risk of bad outcomes, so the wound evisceration could be viewed as negligent care. Poor documentation about care, wounds, and intravenous sites could be viewed as negligent care.